we can start. It's my duty, first of all,
Questo funziona.
to thanks Serena Forlati for this hospitality, for the beautiful surrounding and the nice dinner of yesterday night. But now we have to start working. So the first is Professor Rosario Sapienza. Rosario Sapienza is not here, but he can give his speech via internet, so there is no problem today to do this. Rosario Sapienza is professor at the University of Catania, and will speak about human rights. And so it's very large subject, great subject. And we will ask Rosario to speak about for 20 minutes, because we would like after to have a debate, a Q&A after the speech of the two interveners of this morning. So Rosario, please, you can start 20 minutes, please.
Okay, thank you, Mr. Chairman. Let me thank the organizer for their kind invitation, and also for having allowed me to speak from my place, because due to the strike, I had to change my plans. So I just go to the topic. The aim of my paper is to stress the point that universalism in human rights international protection, though being certainly an ambitious goal, has often been challenged on different bases, and the conclusion shall be that we can reach universalism, but provided we are prepared to strong and heavy negotiations on each single right, each single point. Now, the idea that universalism is a main feature of international protection is, of course, put forward just from the beginning. The beginning is the Universal Declaration of Human Rights, which was adopted by the United Nations. And in this declaration, every single right is starts with the word everyone. Or when speaking of deprivation of rights, the word used is no one. But we shall not find more than these, though important, statements. In the final declaration of the first United Nations Conference on Human Rights held in Tehran in 1968, at article number 2, the declaration reads, "The Universal Declaration of Human Rights states a common understanding of the peoples of the world concerning the inalienable and inviolable rights of all members of the human family." So the idea of the universal protection of human rights is strongly tied to the idea that all human beings are members of a single human family. In 1993, the Declaration on Human Rights, approved in Vienna by the World Conference on Human Rights, starts with a firm commitment, stating that the universal nature of these rights and freedoms is beyond question. And after, says also that the efforts of the United Nations system towards the universal respect for and observance of human rights and fundamental freedoms for all contribute to the stability and well-being necessary for peaceful and friendly relations among nations. So here, the notion of universalism is further elaborated. The declaration speaks of universal in the meaning of the same for all, universal nature, but also speaking of a universal respect, tends to point the fact that everywhere the same rights shall be granted to everyone. So this is the sharpest statement of manifold universalism. Yet, still from the beginning, the idea that it could be possible to have the same rights granted with the same meaning and the same content to everyone all over the world has been challenged since the declaration was adopted. And I would like to say that the declaration was adopted by a committee which was made also by people who were not Western. And also the declaration was made up of rights which were not only those of the Western tradition. Nevertheless, the Universal Declaration was deemed to be from the beginning a product of the Western vision of the world. And when the declaration was voted, the Soviet Union, Belarus, Ukraine, Czechoslovakia, Poland, Yugoslavia, Saudi Arabia, and South Africa abstained from the vote. And in the years to come, several times, the idea that the universal character of the Universal Declaration could be challenged because expression of the Western vision of the world has popped up in the political and also diplomatic debate. For instance, in several occasions, the universal character of the declaration was challenged because the critical approach said had not given adequate room for the so-called Asian values. But more than this, very important was the criticism put forward by Islamic states. For instance, in the Cairo Declaration on Human Rights in Islam, which was proclaimed in 1990, though starting with an Article 1 saying that all human beings form one family whose members are united by their subordination to Allah and descend from Adam, and what is more, the true religion is the guarantee for enhancing such dignity along the path to human integrity. The following articles state a different vision from the idea of the universality of rights. For instance, in Article 6, we read, "Woman is equal to man in human dignity and has her own rights to enjoy as well as duties to perform, and has her own civil entity and financial independence and the right to retain her name and lineage, that we soon are confronted with this statement: the husband is responsible for the maintenance and welfare of the family. And several other articles stress the point that all human beings are equal, but differences, which sometimes are very important differences, should be allowed. But the real problem with the idea of a universal protection of rights started with the approach concerning the multiculturalism, because all that we have said before was due to political diplomatic reasons, whereas the idea of multiculturalism, which developed also in Western fora and was rapidly assumed by the United Nations system, strikes a frontal challenge to the idea of universality. I would like to quote from the UNESCO Universal Declaration of Cultural Diversity, which was adopted in 2001, where culture is defined as the set of distinctive spiritual, material, intellectual, and emotional features of a society or a social group. And this is the first time that in which an UNESCO document accept this definition of culture in, so to say, the anthropological sense. Because in previous documents, culture simply was used to mean masterpieces and things like this. Now, the UNESCO declaration states a point of equilibrium between the guarantee of human rights and the safeguard of cultural diversity, where it says the defense of cultural diversity is an ethical imperative inseparable from respect for human dignity. It implies a commitment to human rights and fundamental freedoms, in particular the rights of persons belonging to minorities and those of indigenous peoples. But concludes, no one may invoke cultural diversity to infringe upon human rights guaranteed by international law, nor to limit their scope. End of the quote. So, since then, a problem, a major new problem arose. In which way we shall operate to make the guarantee of human rights and the guarantee of cultural diversity coexist in a non-problematic way? Well, my opinion is that the only way is trying to negotiate day by day on the content of every single right. And in my paper, I bring the example of the female genital mutilations, which were normed by the General Assembly in the resolution adopted in 2012, where the General Assembly clearly urges the state to adopt laws criminalizing them, even if this practice is deeply rooted in many African tribal cultures. But anyway, it was possible to reach an important consensus by all the states, almost all the states in the General Assembly, because it is obvious that the right of women to the integrity of their body should prevail over the tradition of female genital mutilation. Alas, it is not the same for every right throughout the world. For instance, the right to freedom of expression has always been challenged, even in Western countries, but has radically been contested in those states in which the authoritarian regime is based on the idea that freedom of expression is per se, something which does not deserve protection. So this is the focus of my paper, and I will develop these ideas in the written paper. Thank you, Mr. Chairman.
Thank you very much, Rosario. That there's several topics of discussion, but before opening the floor to the audience, we have the paper of Madame, I will say Professor Elena Fasoli, that she will speak about environment. Environment during these days is very popular, has terminated 2 or 3 days ago the conference in Baku, in Azerbaijan. There is an opinion pending before the International Court of Justice. By the way, I have seen that there is no intervention, at least oral intervention, by Italy. I don't know if there is a written intervention or not, but Elena Fasoli, you have 20 minutes, please.
Thank you so much, Professor Ranzetti. And I just want also to thank, of course, the organizers.
Can you speak louder, please?
Absolutely. I'll just raise my voice. Sorry. Professor Folati, thanks for the hospitality. Everything was perfect yesterday, including the dinner, as you said. But I also want to thank the editors of the yearbook for giving me the opportunity to contribute a paper. So I think I have to explain also the title, because I changed slightly the end of the title throughout the analysis and the research that I've made, because now it's Sustaining Change, the role of the United Nations in promoting environmental protection. It was amid cooperation and contestation, and now it's amid rising discontent. And I tell you why. Because at the beginning I thought I start with the cooperation, the principle of cooperation in international environmental law is fundamental. And I'll just give an overview of examples of cooperation in opposition to examples of contestation. Then I thought, no, let's just focus on contestation. Let's just try to understand what we mean by contestation. Let's see what are the responses, hence the title, Amid Rising Discontent. In fact, within the broader discontent toward international organizations, which I would say some scholars, they trace back to the early 2000s, whereas others, they locate it even earlier than that. So there is also a discussion about when. I try to explore whether this dissatisfaction, this discontent, has also in fact reached the environmental activities of the United Nations. And I've looked at, first of all, the United Nations Environment Program, UNEP, which is the only, I would say, UN body with the environment at its core mission. And then I looked at the UNFCCC, United Nations Framework Convention on Climate Change, and the Paris Agreement. And I also briefly looked at the securitization of climate issues through the involvement of the Security Council. So I will now present a few examples of contestation which I found, and when and where available within these 3 contexts that I just mentioned, also the responses by the UN system. But first I had to turn to international relations to understand what contestation means, essentially, including from them. And there I discovered that it is considered as dissent or criticism directed at norms or institutions, particularly when their authority is questioned. An author, for example, Weiner, affirms that, she says, contestation is an interactive practice that bears contingency with regard to place and time, and which excludes violent acts of dissidents. Contestation is typically voiced through language, but it can also take non-discursive forms, such as, for example, neglect, negation, or disregard. And I started from there, essentially. I took my sort of position. And if I look at the international environmental governance, I would say that contestation usually centers on legitimacy and effectiveness. The two, of course, are connected, but they can actually also diverge, because you can have an institution that can be legitimate, but at the same time ineffective, and vice versa. So, for example, in the 70s, when there was the beginning of the international global environmental enterprise, there was immediately attention between, on the one hand, fairness in representation and effectiveness. Because developing countries wanted, for example, to prioritize legitimacy, and they favored the location of UNEP in the global south. Developed nations, they favored, in fact, effectiveness, and they wanted UNEP in the north, closer to the other UN bodies, essentially. Nairobi was chosen at the end as a compromise to boost, I would say, legitimacy, but the lack of distance also from the other bodies, the lack of connectivity, it remained a contributing factor to the reduced effectiveness of the institution over time. But it wasn't just that, because UNEP also was given from the beginning a limited mandate and also funding, essentially to direct and coordinate the other existing environmental initiatives. This is why in the 90s, discussions about the possibility to centralize the UN environmental governance started, and potentially to transform UNEP into a world environmental organization, or at least into a specialized agency. But the idea did not reach enough consensus. Meanwhile, the paradigm of sustainable development emerged, and it started to formalize also and to reframe, I would say, environmental issues that were just environmental in the past, before that, also as social and economic concerns as well. And this further diminished UNEP's authority. In fact, the program was not seen as authoritative enough, I would say, to handle complex issues like climate change, much more complex. And that's why in response, in 1990, the General Assembly established a negotiating committee leading to the adoption of the UNFCCC in 1992, thus shifting again further away environmental governance from UNEP. The new regime, specialized regime, relatively autonomous, surely was able to address climate issues more effectively, but it fragmented the system. At the same time, this decentralization likely acted as a containment strategy to address concerns, particularly from developing countries, and it reduced resistance while maintaining engagement. But even the climate regime did not escape criticism. And here, I think we should distinguish between criticism directed to the processes like the COPs, Conference of the Parties, which we just mentioned, were concluded a few days ago, which under certain circumstances, they could be interpreted as contestation of the UN itself, and the criticism directed to the content of the rules adopted within the UN process, where the UN there serves as just a platform for contestation rather than being the target of the contestation itself. Although the distinction is a difficult one to be made. Non-state actors, first of all, I just refer, for example, to youth-led movements started, like I just mentioned, Fridays for Future, for example, started to contest the perceived lack of ambition of the climate regime, targeting the effectiveness. Here, though, I would say that the discontent did not target the core legitimacy of the UN process. In response, though, the UN started to institutionalize more youth participation within the COPs, showing growing recognition of these voices. Also recently, the Secretary General of the UN appointed a special envoy for future generations, for example. This should be read against a rising trend in international environmental governance towards recognizing a wider range of actors as legitimate participants. And this surely introduced challenges of coherence, coordination, surely, but at the same time, this is actually to be seen as another response of the UN system to mitigate discontent. States also have contested the climate process at key moments. The first was in early 2000 when the US administration rejected the Kyoto Protocol. And because of this, alternative fora began to emerge, like, for example, the Asia-Pacific Partnership on Clean Development and Climate, launched in 2006 amongst the ASEAN countries. And this was, at the time, criticized as this minilateral, I would say, parallel tracks, as cynical exercises in destabilizing the UN process. However, some participating countries, such as, for example, Japan, they quickly clarified this partnership is complementary and actually supporting the UNFCCC. Then there was a second moment of contestation, which was in 2009, during the discussions on a post-Kyoto framework, and the impasse at COP15, where developed countries refused to commit to further targets without commitment from the emerging powers. And this resulted in just a political declaration. And the failure was described as a legitimacy crisis of the UN climate regime. Then there was another moment, the third, I would say, where contestation was seen when President Trump withdrew from the Paris Agreement, and in 2017, then followed by other skeptical stances from, for example, President of Brazil, Bolsonaro, and also some European leaders. And I think probably we should add now a fourth phase, because it's very likely that there will be another disengagement from the Paris Agreement once Trump will be taking office. The UN climate process has responded to this contestation by decentralizing and softening the obligations. This introduced, for example, the concept of national determined contributions in the Paris Agreement, enabling countries to set their own climate goals while focusing on procedural elements like reporting and review. And this approach surely moved away from rigid distinctions between developed and developing countries while acknowledging different national circumstances. Scholars describe this reliance on self-determination as the ultimate institutional strategy to maintain inclusivity amid political divides. I would also add to this the role played by the bureaucracies of the bureaucracy of the institution. For example, the Secretariat of the UNFCCC that has set up in time alliances, for example, with other actors, non-state actors, essentially, especially, including in order to ease resistance. So the UN climate process has showed resilience despite criticism. The minilateral initiatives initiated by states outside the framework UNFCCC have been eventually reabsorbed, and even the high-profile departures like the US one eventually did not lead to broader exit from the, I would say, the system, the framework of the Framework Convention. Instead, the UN legitimacy was reaffirmed, including thanks to initiatives such as the subnational responses to the US withdrawal, like, for example, US Climate Alliance between several US states, climate mayors initiatives amongst the cities, US cities, which demonstrated continued subnational, in this sense, commitment to the Paris Agreement. back to international relations scholarship, because they describe this dynamic where contestation and legitimation are intertwined as a holistic process. The idea is that instances of contestation do not necessarily undermine legitimacy. In a way probably not too distant, I have to be very careful here, not too distant from uniformity of practice in identifying customary international law, we could say that if a contesting state continues to engage with the institutional framework, and if the contestation sparks a reinforcing response, the institution can still retain legitimacy. So despite contestation, the UNFCCC process has managed to retain fundamental support, although not necessarily effectiveness. In fact, as we know, too much accommodation can come at the cost of diluting the regime and the objectives, and potentially fueling further contestation. To address this, for example, very recently there has been a call for reform of the COP process. It came from different actors, including UN Secretary General, former Secretary General Ban Ki-moon, former Executive Secretary of the UNFCCC, Cristina Figueres, and they are essentially they're saying, we need to shift from negotiation to implementation, and they propose to transform the COPs into smaller, more frequent, solution-driven meetings where countries report on progress and are held accountable in line with the latest science. In other terms, another step towards institutional decentralization. So up until now, I have referred to instances of contestation and responses within the environmental governance led by the General Assembly. Now, I will refer briefly to the similar dynamics within the Security Council. Where there is a progress, and I would say a progressive securitization of the climate issues, which began prominently in 2007 and culminated, I would say, in the vote on the 13th of December on the draft resolution 990, which was proposed by Ireland and Niger, but vetoed, as we know, by Russia. Here, contestation essentially unfolds along two main lines. On the one hand, the states that advocate for the explicit linkage between climate change and the global security, arguing that the Council must engage with climate change, with climate security, essentially. On the other hand, the states that oppose such involvement, asserting that climate change should remain within the mandate of the sustainable development bodies like the UNFCCC, General Assembly, essentially. However, while states are debating which UN venue is more appropriate, is best to deal with this issue, I think that this should be seen and read again as another example of how the UN system contains climate-related discontent through the involvement of an additional UN body, so through increased institutional decentralization. So overall, looking at these selected elements of the UN environmental system, and of course I acknowledge I haven't covered all the institutions, organizations, agencies, regimes, including those that are not dealing with the environmental issues only, it appears that both institutional and normative decentralization has shaped the UN environmental governance in several ways. This decentralization as a containment strategy was reflected in the dilution of the environmental issues within the broader sustainable development framework, the example which I made of the UNEP, in the involvement of the diverse UN bodies and actors, with the example of the UNFCCC, non-state actors, and the Security Council, and in the shift towards bottom-up commitments, with the example of the Paris Agreement. This has undeniably contributed to fragmentation, challenges to coherence and coordination, and ultimately implications for effectiveness. However, this should be understood in the context of a continued engagement with the UN system, which shows its enduring resilience in the face of criticism. And probably the reason for this, because why is this happening essentially? Maybe it's the higher awareness for the urgent need to take action to protect the environment and to not throw everything away, everything which was done. But the UN bodies seem to remain the indispensable platform for the advancement of environmental protection. And I would just conclude and close with borrowing, if I can, the words of Professor Daspremont in his contribution called The Love for International Organizations. And I would say that discontent with the UN environmental system has prompted calls for reform and change, but not yet for radical disruption. I thank you.
Thank you very much. Now we have for discussion about 20 minutes before the coffee break. So I would like to start with the discussion on both papers and the approach from the point of universality, as Professor Rosario Sapienza said, and the other hand is the approach of contestation and fragmentation, as noted by Professor Fasoli. So the floor is open.
May I?
Please, since I don't see very well, you can start identifying yourself when you are taking the floor.
Thank you. I'm Serena Forlati, and thank you very much for two very, very interesting presentations. I have a question and a comment for Elena Fasoli. The comment is that it seems that your conclusions about the approach to the UN as such, at least it is my feeling that is something widespread. The idea that the UN is not working properly in many areas, but still we cannot do without it, and it would be much worse if we disrupted the system completely. And yeah, this is something that your conclusions brought to my mind. And the question is, what do you think the impact of the advisory opinion on climate change might be on this system? What do you think the request for an opinion is part of this attempt to, shape the development of this area of international law, notwithstanding the resistance within the institutionalized framework? Do you think it will be a useful contribution? What is your idea about the possible impact of the advisory opinion? Thank you very much.
So we will have other questions or comments before the two speakers answer.
I'm Riccardo Pavoni, Professor Ronzitti. I'm here. I thank both speakers, both Professor Sapienza, Professor Fasoli. About Professor Sapienza, of course, this topic is a very well-known topic. It's increasingly relevant, it's always relevant to speak about universalism versus multiculturalism of human rights. So I think it's this is an existential issue in a way when it comes to the protection of human rights. Perhaps my question is about if you could engage more with the UN infrastructure about how the UN bodies have dealt with this topic. For example, one question would be, do you think that the creation of the Human Rights Council has made a difference here? Has anything changed vis-à-vis the previous situation when we had the Human Rights Commission, the famous Commission of Human Rights, which was, as you know very well, accused in the past of being politicized, and so that brought about let's say the collapse of that body with this replacement of the Human Rights Council. Does the Human Rights Council has made a difference? And about Elena Fasoli, I appreciated very much your discussion and how you intend to write your paper. I basically agree with everything that you said. I just want to, I mean, Serena said very well, that she got your point that, you know, the UN system shows resilience when it comes to contestation of its engagement with environmental protection. But I mean, my position would be more optimistic here, because I think that the UN here has really played a crucial role. And I think that you said that in your presentation. When I talk to my students, I always said, you know, the UN is not only about peace and security. It's also the UN is a body which is engaged with many issues, many fields of activity. And if I want to make an example of a success story, I always make the example of environmental protection. I don't know whether that is wrong, I'm too optimistic or not, if you share that, starting, of course, this is a long story, starting with the Stockholm Convention in 1972. But I always ask myself, what would the world be without the UN engagement with environmental protection?
Okay, thank you. There are other comments or questions, please.
Carlo De Stefano, Roma 3 University. I also have a question to Professor Fasoli, and on the premise that the Paris Agreement is, of course, in continuity with the UNFCCC agreement. Actually, the Paris Agreement has been adopted in the framework of that convention. My question is about the role of the Security Council, and more precisely whether in this idea of securitization you are going to consider powers that may relate somehow to implementation and enforcement of climate commitments, having in mind that these elements are relatively weak under the international climate change regime. Thank you very much.
Okay.
Thank you. So I will keep another questions or comments. Please, anybody? No?
Yeah, it's Marco Pertile. I have a question. So it's for Professor Fasoli. Thank you very much, Elena, for your talk, and apologies for being late. I wanted to ask you, referred repeatedly to the sociological concept of norm erosion. And the proponents of the theory, if I understand that correctly, they distinguish between two forms of contestation, which would lead to norms erosion, and you refer to that, I think. So it's a contestation aimed at carving out exceptions, and contestation of applicability and validity. So two different forms of contestation. So I wanted to, which would bring about norms erosion. So I wanted to ask you if, to clarify whether you see both processes at play, and whether you see a linkage between the two. Because I'm under the impression at times so many exceptions have been carved out in some of the rules that the contestation of applicability and validity is not even necessary. So I wanted to ask you if you see this linkage, especially in climate change, norms being watered down so that contestation of applicability and validity is not even necessary. So I wanted to ask you to take position on this.
So thank you very much. Now the two speakers can answer to these questions and comments. I will start with Rosario Sapienza, because there was an interesting question about the Commission on Human Rights, Council on Human Rights, and so on. Please, Rosario.
Thank you, Mr. Chairman. Well, I must confess that I have no documents concerning the Human Rights Council. I have not seen documents from the Human Rights Council in order to prepare my paper. And of course, I promise to take into account this useful suggestion by Professor Pavoni when finalizing my paper. Well, I should say that I think that the real novel approach brought by the Universal Periodic Review by the Human Rights Council may probably change something, because the way in which the states are scrutinized in open doors method should bring more and more diplomatic work, and so increase the protection of human rights, even in those states which are traditionally refraining. This is what I can say for the moment being. I shall go into the matter. Thank you, Mr. Pavoni.
Thank you very much. Professor Fasoli, you have been addressed several questions in the comments.
Thank you. Professor Forlati, so in fact, that was my conclusion. We cannot do without it. And I see the advisory opinion as an integrated framework that the same terminology that you, Alessandra, yesterday used. All of them, like strategically, all of them, they contribute surely to the clarification of Article 4 and the threshold for the breach of Article 4 contained in the Paris Agreement, and what entails for the states being checked upon the efforts to reduce greenhouse gases. But strategically, it is much broader than that, because, and also, I see even the inclusion of the Security Council, a strategic sort of diffuse approach to involve all the different organs, and surely it couldn't be a contentious case and just an advisory opinion, because actually that was the second best option, in a sense that we cannot have the interstate small island state versus big emitter case, because it's really technically impossible in a sense. And that's why they had to resort to the more feasible and more acceptable option of an advisory opinion. So that is, to me, another decentralized approach to a much bigger problem, and how to involve the bigger UN bodies to deal with it, in a sense. Professor Pavoni, yes, in fact, I am optimistic, but I also say that the environmental issues, they were built, I would say, from the beginning as very much inclusive, in the sense, Professor Sapienza, in his presentation, mentioned the fact that the declaration was seen, in fact, a product of Western countries in reality, right? I think it's different when it comes to the international environmental governance, because from the beginning there was this dynamic of negotiation north-south from the beginning, I would say. So it was a continuous discussion, an inclusive discussion from the beginning, and it wasn't, I wouldn't say, seen so much compared to other regimes, other institutions, as a product of Western countries, I would say. That's why probably it was a little bit more successful, less contested, more inclusive, surely diluting watering down the norms, and then I'll come to you, Marco, but clearly it was something which was, as a built-in element, which constituted probably an element of success. Carlo, you refer to the continuity of the Paris Agreement with the Unife CCC, surely, and referred to the securitization and whether the securitization of the Security Council has a say in power and implementation and enforcement, essentially. So I give to you, I connect with my overall answer that is strategic, that involving also the Security Council is strategic, but when it comes to enforcing in concrete terms, should the issue be eventually with a thematic resolution being addressed by the Security Council, I don't imagine seeing the Security Council adopting sanctions against one state that hasn't, for example, showed enough commitment to the Paris Agreement or has not reduced enough the emission targets. Maybe it has to do more with, and that's another angle in which the Security Council is playing a major role, in peacekeeping operations, for example, including climate security language in the mandates of peacekeeping, operations, employing personnel dedicated to that issue, right? Which could be helping, connect the security element with the climate and environmental element. That's a very concrete, I would say, enforcement or implication of the securitization of the Security Council with climate issues. Marco, so you mentioned actually norm erosion. And yes, I took it from the references to the scholarship and the sociology and international relations. So to your first question, I would say that it is a validity contestation, that it is norm eroding the erosion of the norm between the two options that you gave me. At the same time, you also said that at some point the process, it is so watered down in terms of the norms that you don't have any more an issue of validity. Well, I tell you that there is an issue anyway of discussing, validity or discussing effectiveness, even when those norms are so diluted that they are practically not empty, but pretty much, exactly reduced to the core, so to say. Although I referred to that theory, not to norms, more to institutions erosion. Because sociology and international relations, they talk of erosion of legitimacy of institutions and norms, and I picked up on institutions rather than norms. Did I address everything? I hope so, yeah? Can I just ask something about Professor Sapienza's, if I just can I interject with the other presentation, if I'm allowed to interject and to comment upon it? Because while I was, in fact, searching and studying for the examples within the Security Council, I happened to see that the mandate for peacekeeping, the language, the environmental language of climate security within the peacekeeping operations mandate, it goes hand in hand with the language of human rights, most of the times, many times. And I've seen examples in which China, example, one of the most important and higher donors for peacekeeping operations, I would say, they have been essentially trying to use and to take out the language of human rights from the mandate to peacekeeping operations, including the language of the climate security, surely, because of this cultural, essentially difference. I've read, for example, China's Armed Forces 30 Years of Peacekeeping Operations, which was published in September 2020, and I didn't find a point of human rights. Why? Because the approach to human rights, of course, it is completely different. Their approach is not of an individual point of view approach, but it is a sort of harmony of the society approach, where the role of the individual is functional to the society, harmonious community, I would say. So it's not surprising to see that you don't find that type of language in those kind of mandates, and you instead find points of economic development, social stability, rather than individual human rights. Because, as I said, as Professor Sapienza said, the values are different, completely different. So it's a battle even within those kind of mandates that are sent and prepared. And I just stop here because I don't want to monopolize the discussion. Thank you.
Okay, thank you. There is just 1 minute, or 2 minutes. I would like to ask questions to both, if possible. It's about the sea rise level and the fact that 2 or 3 or 4 ocean states will disappear. But what will disappear? Just the territory or disappear the state? What about the relations between the principle of self-determination and this phenomenon? So for one part, there are human rights, self-determination, but for the other, there is environment. So when we say state will disappear, what means physically disappear? Just the territory, but those people should be located in other places. What about the principle of self-determination? Thank you.
Who is going to start? Professor Sapienza, do you want to start, or shall I start?
So?
Please, okay. Women's first.
Okay, thank you. Thanks a lot. So, sea level rise has been the topic, one of the topics, of course, of discussion within the ILC from some time now, and it's been quite interesting to see the division of their work into different components. The component of statehood, the component of the displacement of people, and the component of the maritime delimitations. So, Professor Ronzetti, you are referring essentially to the displacement angle. I would say that it is arising out of the disappearance of the small island states from the Earth's surface, essentially, because they are disappearing, in fact. So, I think that at the point they are, including other discussion at the ILC level, but they are discussing about, for example, humanitarian visas to be given to the relocated populations within a different country, that they have to host them, essentially, because of the displacement. I think this is one of the angles that's, according to the latest discussions and the outputs from the ILC, it has been essentially recognized as a viable option, I would say. Very even practical, because at the end of the day, the state disappears territorially, but not the statehood, and not, of course, the entitlement of the population, for example, being relocated in New Zealand, to receive protection for their, including for their rights. This, I think, has to do with the possibility to receive protection, I would say. And I leave also to Professor Sapienza.
Okay.
The other.
Rosario.
Thanks.
Yes, thank you, Mr. Chairman. Thank you, Elena. Well, I must confess I'm not familiar with the debate ongoing on the subject, but I should do some of, a guesswork. I think that we must find a way to safeguard the right to self-determination. I know that not all the states, including our state, are prepared to the idea that aliens should come and preserve their cultural identity. The most that we hear in Europe, except for United Kingdom, which is now out of the European Union, is that they must come and try in a way to do their best to change their ways of living and adopt the ways of living of the place in which they're hosted. Now, these should not be the same, because you cannot relocate an entire people and don't grant him the right to self-determination. I think we have a lot of work to do on this issue. Thank you.
Okay, so thank you very much. This is now the time for the coffee break. I know the break, but I don't know where is the coffee. Serena Forlati will say, where is the coffee? And you have just 15 minutes, 1-5, no more, please. And after, yes. Ok, thank you, Rosario.
Dicevo per il collegamento, non so se il professor Sapienza ci sente.
C'è qualcuno. So the meeting we will resume now, and the first speaker is Professor Kremer. Professor Kremer will speak about slippery slopes, and he should be very careful because we have a member of the International Law Commission, so be careful about the slippery slopes. They are not for you, but for the ILC. Please, Mr. Professor.
Share the microphone because I don't see it. Yes, yes. I think we share this. Thank you, Mr. Chair. I am aware of that presence. In fact, when the organizing committee asked me a topic, I said, I would drop a topic, but I see that in the organizing committee there is. And I said, so please tell us. And I said, well, I would dare to talk about this. And I said, yeah, go ahead, go ahead. I'm not going to talk, so you will have the you have the martyrdom just for you. All right, slippery topics. It is a slippery topic in itself to talk about the International Law Commission, not just because of the presence of Professor Nesi in the room, but because everybody knows at least something about one of the many topics. And I cannot cover all of them with the depth and the knowledge that each of you has for at least one, but this would be very harmful to your reputation, so I'd say more than one topic. So I'm not going to engage with the works of the ILC, not all of them, into details. I will just take a zoom out on the work of the ILC in light of the topics that the organizing committee decided to put forward for reflect together. Contestation, resilience, and change. So I am in the last panel. After the second coffee break, just let me thank everyone who is involved here, from the professors to the PhD students. Wonderful organization, happy to be here. But as always in Ferrara, this is not the first time, it is clear that there is an idea of not being banal and not being behind something that already been explored. To talk about the UN today, and contestation can be labeled as quick if we look at North-South or whatever. It's clear that it's something different. You know, there are wars out there, and there are major reforms that are not happening, and the ILC is out of it. So that's the first point I would like to raise. The ILC is a solid rock in the middle of the waves. There's not an open political contestation. I led to Professor Nesi maybe the stories of political contestations happening there, but they don't filter, they don't come out in the results. There's not a West against the rest, like Tunkin, one of the members of the ILC during the great codifications that was contesting international law as pure expression of Western hegemony, a member of the Soviet Union government. And therefore positivism, once again, a strict literalism put forward by Gregory Tunkin as a tool to avoid politicization. So nobody loves positivism on paper, but then when you have to talk to the world, maybe it's the best we have. It is not the time of open contestation of the structural rules, like, again, we go in the 60s, when certain scholars from North Africa and Middle East started. It was not yet called the critical legal studies, but it was called just contestation. So the idea that customary rules could be rejected tout court as such, because based on an old legal system. Okay. Paradoxically, today we have a very strong contestation within our own societies based on race theories, identity politics. The topics of North versus South affect, for example, climate change discourse, but the ISC is a bit immune to this. There are some, but not to the degree that we experienced in the past. So I would not talk a lot about political contestation, and I will stress the function that the ILC took in the last 25 years, in the last quarter of century, in being a rock, being aware to be a rock. So an element of resilience. The ILC decided to look at one of the many phenomena that were affecting the international community and the community of judges and the community of scholars. It's like the ILC in the last 25 years decided to change to keep its prominent place in international law, to adapt to the different audience it had. And after the Berlin Wall, the codification of international law was not anymore the most important thing. The most important feature of the international society was the creation of courts of different kinds. And a new audience, and not just the ICJ, was in front of the work of the ILC. Many judges were interested in the work of the International Law Commission. And the International Law Commission stopped basically drafting articles for international conferences to elaborate a set of analyses and distillate some guidelines, practice, conclusions, depending on the work. They were up for grab to the international community of judges, first of all, and of lawyers, of course, that needed some work to quote in cases in which they were representing a state or a private investor abroad. So the first element that threatened the unity of international law in the last 25 years, the so-called proliferation of courts, was taken by the ILC as an opportunity. It is not a threat, it is the proliferation of the possible users of my work. And reasoning that the ILC proposed is not explicit. We don't have, statement of the ILC of this transformation. We just have the numbers, okay? So at the moment we have, including some works that were split, 37 works that were completed by the ILC and 5 were concluded. Of them, concluded that says they were eliminated from the docs. Discontinued, pardon. So 16 culminated in draft articles that ended up in the adoption of a convention. 12 became articles that were not then adopted in a convention. And then we have 13 topics that ended up with guidelines, 5 of them. Another 8 were in the form of a study. So a study guide, maybe with conclusions, maybe not. So for example, the work on fragmentation had conclusions that are very thin. The important part of the work of fragmentation is actually the report, 240 pages, whatever. The work of Jus Cogens, on the contrary, is very scholarly, but had many conclusions, more than 20. We included annexes. So if you look at our conclusion 22, refers to a non-exclusive list of what are the peremptory norms of international law, linking to annexes. So that's kind of a new technique, incorporating the scholarly work in an ordered way. And then we have, whatever it is, the work of Alain Pellet on reservation, where, hat off, in the sense that for Jus Cogens, we didn't have much practice, but a lot of scholarly work. Poor Alain Pellet had a huge amount of contradictory practice. So he said at a certain point, I think his introduction to the final report, I had to come up with some conclusion and description, but it makes clear with very polished language that it was time to draw a line, even if the practice was not conclusive. 6 more studies don't fit into any category because maybe we're adopted for temporary issues like the transition from the League of Nations to the UN Charter, specific studies that were used on with a clear task. But if we focus just on what happened after the year 2000, we have just one treaty that was adopted on the work of the ILC, and is the Convention on the Immunity of States, 2004. That's the last work that ended up with hard law, with a proposal of hard law. It was also lucky because the ICJ quoted that convention as expression of customary rule, but not just one, but the ICJ picked some of these norms with a technique that is used by the ICJ and other courts and tribunals for many other works of the International Law Commission. The clear case here is the set of articles, first draft articles, and today articles on state responsibility for wrongful acts that are not hard law, but they are written and they are applied as customary law. And the technique here is clear. We don't apply the articles as a treaty, but we apply them as a restatement of customary law, and all the work on practice that the ILC did becomes binding in the words, aside from the practice of states, in the words of a judge, crystallizing them. So not through the moment of debate and consent in a diplomatic conference, but through the back and forth between lawyers and judges, crystallizing the status and the limits of the precise boundaries of a rule. Sometimes with contradiction, state of necessity. What is state of necessity today? Go figure. But more often with progressive development, using the UN Charter language of international law, operated by the ILC that decided to lead this kind of unity of international law, to be an element of resilience facing one of the elements of fragmentation that I mentioned, that is the proliferation of courts and the proliferation of regimes. For sure, the second element of fragmentation that the ILC took seriously is the fragmentation of states. We moved from 50 to 194 states, so the ILC had to deal with more competing interests and was not affected by it. Okay, to keep the work steady and was able to manage the waves coming from these widespread, diffuse interests. Again, focusing more on the elements of unity of international law, that more of the Security Council is the judicial moment. Sort of subsidiary application of the unity of a legal system. Given the lack of coherence of 194 states lacking the political energy to do something together, in a subsidiary fashion, we go to the next level of political activity, which is the judicial activity, where we can develop general norms, talking to only affairs inter partes, disputes between parties. The third element, for sure, of fragmentation is that the ISC had to address and tackle down was the fragmentation of scholarship. Maybe because of the internet, maybe because of Fascia A and other publications, but there's too much writing around the world. More people are interested in international law, more people are writing. So the ILC decided to become, again, not on paper, but de facto, to decide to become the official scholarship of the world. So in those 25 years, the ILC took two kind of questions at stake. First was the part of the system after the rules on responsibility. I follow Hart, the philosopher of law, the rules on the creation of rules. And so all the work of sources that is still going on, we're getting to Article 38 to 1D of the statute of the ICJ with other decisions and scholarly writing. We have general principles ongoing. So the slippery topics are not anymore something for the introduction of Oppenheim international law. It is something that the ILC takes on itself with this scholarly purpose, to propose to a fragmented world of scholars, to propose to a fragmented world of states, to propose to a fragmented world of judges a unified restatement of the most qualified practice and scholarly work that are easy access through the internet. Let's not forget that now we have the medium, we have the means to access, we have, with one click, a quick reference proposed by one of the most qualified organs of the organs, not in a technical sense, organs of the international community, no, the lung pumping a reflection on law out there for the rest of the world. Sorry, I go back to one of the works, but if you look at the cases and the scholars quoted in the work on the use cogens, it's just outstanding. How different is it compared to 30 years ago? The number of, the variety of nationalities and courts that are quoted are way beyond imagination if we look at what was quoted many years ago. So the ISC decided to place itself as a different actor, no more proposing hard law to govern in a hard way specific topics, but to become, maybe embracing the idea of soft power of NAI, to embrace a broader picture and to propose a framework, applicable law sources, for the application of international law, and a content, a qualified content to browse and study, on the other hand. Therefore, maintaining the unity and let's say, validity of international law in a different way compared to its task many years before. So I spoke for 17 minutes. Give me a few more so I can get into one of these topics, and then I will stop. Now, what is the success of this endeavor? Sometimes it is not successful. I spoke about Pelé work, and it is not the most used reference in dealing with reservation. Often, judges prefer to go back to the Vienna Convention, Article 19 and 20, and then check what the relevant practice for that question, for the question at stake. The very specific work on the most favored nation clause, on the contrary, is often quoted by arbitral tribunals on investment law, because it was an open question. It was not a slippery topic. It was a difficult topic, but it was not a very theoretical issue. So what's the value? What are the clauses in a treaty that should be included in the most favored nation clause? Some cases went in one direction, some others in another. Jurisdiction is included or not. The ISC decided to step in, looking at the practice again. It was not talking to states. It was talking to arbitrators. And said, wait a minute, let's take together this practice, let's see what's the purpose, and made a very thin work that is often quoted to basically cut the problem at the origin. Other works are dealing with very slippery issues. For example, the question of sea level rise, the mitigation that comes out of it, still ongoing. And we have the twin part of the advisory opinion, going into unconventional way to promote and develop international law. We have general principles, as I said. We have use cogens. Use cogens was fast. It was introduced to the work of the ISC, attracted a lot of scholarly work before the starting of the ISC, and after that the ISC started working on it. And then nobody's writing anymore about use cogens. I think that in the last years, nobody, because it just came the last cut with the publication of the conclusions of Professor Tladi, now Judge Tladi, sorry. And the work had an immediate impact. 2022, the conclusions were adopted, presented to the General Assembly, and they were quoted already in 2023 extensively in the dispute, in the advisory opinion, in the written briefs presented to the ICJ on the legality of the occupation of East Jerusalem and the West Bank. So now we have the advisory opinion. I look at Serena because we spoke about the advisory opinion before its publication. And the work of the ISC is not only quoted in the written briefs and, of course, was presented in the oral presentations by some states, but is used by the International Court of Justice. It is not quoted but it is used in the part on self-determination, for example, at least in two ways it's used. In the part of self-determination, when for the first time in history, the International Court of Justice couples self-determination not only with erga omnes character of the obligation, but also with the peremptory character of the obligation. So taking conclusion 22 into the final opinion. And this point is stressed by several judges in their opinions or dissenting opinions, referring more extensively to the work of Tladi. Of course, Tladi is now a judge, a few months he's in, and therefore Judge Tladi quotes extensively the work of the ILC that he wrote. So, yeah, when I speak about the internet, I also mean the use of Word that was mastered by Cansado Trindagi probably, and the copy-paste function, because sometimes just in a few hours you have very long dissenting opinions or opinions. So you see that here, and I conclude, the work of the International Law Commission as an element of resilience and interpreting the change of times shows in 2 years how something that was very scholarly, that we all know the few cases, you know, the many cases in the Inter-American Court of Human Rights, the few cases of the ICJ that dealt with use cogens. All of a sudden, all the work the scholars put out became something that was quoted by states before the ICJ, that the ICJ brought as peremptory norms up to the public, sealing the circle and showing how norm creation is today something that the UN happens. It doesn't happen anymore at the UN General Assembly. It doesn't happen in diplomatic conferences. It's happening in Geneva with few people working hard, not paid enough. Not to quote him, but Koshkeniemi, when they offered him to the renovations, I didn't know what I was dealing with. No, this is just excellency for nothing, basically. And sealed by the very visible College of International Lawyers that, as arbitrators or judges, receive and seal the final conclusion of these norms. Thank you.
Well, there is much material for discussion after the Professor Viterbo address. Professor Viterbo will talk about the specialized agencies. One time, I remember one author said that the United Nations are the government of the world, and the specialized agencies are the ministries of this government. But with the anarchy of the international order, I guess that this theory is no more tenable, even though at the beginning it also was just in the mind of some authors and nothing else. But Professor Viterbo will talk about specialized agencies in relations with the United Nations today. Thank you.
Thank you, Professor Ronzitti. First of all, thank you for having me. It's always a big pleasure to be back to Ferrara. So thanks for this invitation. Specialized agencies. So when I began thinking about how to approach this topic, what immediately came to my mind was the expansion of their activities beyond their mandates, something that is often referred as mission creep. However, with 17 highly specialized agencies in existence today, I decided to take a broader, more horizontal approach to the topic, focusing on aspects that they all share in common. So therefore, I turn to two topics, two classic issues in the law of international organizations, membership and representation. Initially, I assumed that on these aspects, specialized agencies were entirely independent from the United Nations. But after completing my research, I can confidently say that this is not always the case. So in what follows, I'm going to describe the incomplete autonomy of specialized agencies from the UN on the key issues of membership and representation, and I will explore the consequences of this relationship. So my first question is, it's divided in two parts, my presentation. The first question is, how much autonomy do UN specialized agencies have on membership and observer status? It is widely accepted today that membership in the UN serves as a sort of imprimatur of statehood. However, as written by Marina Mancini, which I don't know if she's here, still here, there are two diverging opinions on the value that the admission of a new member state to the UN has. According to our first line of theory, the international community has delegated to the United Nations the authority to certify statehood, sort of recognition by collective means. A second line of theory advocates instead that it is not possible to recognize a rule of collective recognition in the admission of a new state to the United Nations. This said, even if each specialized agency has its own membership rules, in several cases of state succession, these agencies have indeed followed the lead of the United Nations. This typically occurs when continuity of membership, succession of membership, or the need to apply ex novo following the extinction of a former member state are observed. In these cases, we have a de facto coordination among UN family organizations. This occurred, for example, just to make a well-known example, when the UN Security Council and the Assembly determined that the Federal Republic of Yugoslavia could not automatically succeed in UN membership and had therefore to apply anew. In that case, nearly all specialized agencies align with the UN position. This coordination does not extend, however, to situations where states or entities that are not yet UN members seek admission to specialized agencies. I'm referring here to entities that either lack sufficient international recognition to secure consensus on their admissions of voting in their favor, or whose international legal personality is not clearly established. The cases of Kosovo and Palestine well illustrate the issue. As you all know, Kosovo became a member of the International Monetary Fund and of the World Bank in June 2009, when the ICJ had yet to issue the advisory opinion on the legality of its declaration of independence, and while Kosovo bid for UN membership proved unsuccessful. Palestine, on the other hand, is a member of UNESCO since 2011 and also a non-member observer state in the United Nations. More recently, in May of this year, the General Assembly granted Palestine additional rights and privilege of participation, among which, for example, the right to submit proposals and amendments, and even co-sponsor this proposal and amendments. This was done on a very exceptional basis and with no intention of setting a precedent. So very wide, widen power of an observer state. In addition to that, the General Assembly urged and requested specialized agency to confer Palestine the same broadened participation rights. And both the World Health Assembly and the ILO aligned themselves as provided for by Article 4 of their relationship agreements, even if this is not provided in mandatory terms. Other specialized agencies are expected to follow suit, apart from the Bretton Woods institutions, the IMF and the World Bank, IDA, IFC, whose relationship agreement conferred them greater independence from the United Nations, very special independence as compared to other specialized agencies. However, one might question whether these agencies are under an obligation to grant Palestine such an exceptional legal status, which is not even provided for by their respective founding treaties. There is no mention of observer status in many of the founding treaties of specialized agency, not to mention these enlarged powers granted to Palestine. Moreover, Palestine should be ever accorded these exceptional participation modalities. This might have an impact on certain procedural rules. I provide you the example of the ILO, where granting Palestine enhanced participation rights in the governing body could lead to a situation where an observer state will have more rights than ILO members that do not sit in the governing body. So this has to be carefully reflected. But more importantly, when membership in a specialized agency can become a window to international treaties. When a non-UN member state joins a specialized agency, it might gain the capacity to participate in UN conferences and treaties. The level of inclusion of non-UN member states in conference convened and treaties adopted under the UN framework is set, as you all know, by the formula adopted, which may be either the all states formula or the Vienna formula. Under the all states formula, only entities that have already acquired statehood are enabled to join. And in this case, the UN Secretary General, acting as depository of the treaty, will accept a signature, ratification, or accession only if there are unequivocal indications, I'm quoting, from the General Assembly that the Assembly considers a particular entity to be a state. So there is a reference to what the UN does. The Vienna formula is used instead to clearly identify beforehand the entities that will be eligible to participate in a treaty. This approach was developed in occasion of the Vienna Conference on the Law of Treaties, specifically to overcome the uncertainties, the gap left open by the all states formula. And in practice, this permits participation by UN members, parties to the ICJ statute, and members of specialized agency, even if they are not UN members and their international legal personality is still disputed. In other words, when the all states formula is adopted and the UN General Assembly treats an entity differently from a state, that entity will not be allowed to participate in a conference or a treaty, even if it is a member of a specialized agency. On the contrary, when the Vienna formula is adopted, the Secretary General will arrange for the participation of non-UN members of specialized agencies without having first to assess the position of the Assembly and assess whether the Assembly regards them as states. So I know this might sound complex, but to provide you some example, this framework, the all states formula or the Vienna formula, produce very different outcomes for entities like Palestine and Kosovo. So whereas Palestine is permitted to participate under both approaches, Kosovo may only participate if the Vienna formula is adopted. And to make another example, this means that both Palestine and Kosovo may decide to ratify the Genocide Convention, which follows the Vienna formula, while only Palestine may join the Apartheid Convention, which follows the all states formula. So this distinction underscores the important role that membership in a specialized agency plays for a state's international engagement. Membership in a specialized agency does not just grant access to the agency itself, it can open doors to broader participation in the UN legal and treaty-making framework, with all the consequences that you can imagine. So this might explain, for example, why Taiwan is seeking membership in the IMF and has just put forward this request at the IMF World Bank annual meeting. So this was about talking about membership and observer status, and I will now move to the second question, on which I promise you I will be brief, which is how much autonomy do UN specialized agencies have on representation issues, so on the credentials process. I'm not going to dive into the specifics of how the UN credential process works, or describing the criticism it faces due to claims of increased politicization, but I will focus on the fact that to avoid inconsistent decisions regarding representation, in 1950, the General Assembly adopted a resolution back then by which it recommended a specialized agency to take into account its credential decisions, so what the UN credential process decide as an influence on what's happening inside the specialized agencies. Should have, at least. UN recommendations on credentials, however, have not been uniformly accepted by specialized agencies for both legal and practical reasons. First, relationship agreements do not require a specialized agency to implement UN Assembly's recommendation, but only to submit those recommendations to their competent organs for discussions. So there is an open door for them to do something different. And second, there is often a temporal misalignment. Specialized agencies are often called to decide on credential way before the Assembly has had the opportunity to make its own determination. And the recent case of Myanmar provides a good example of the resulting fragmented scenario. After the 2021 coup d'etat, the General Assembly allowed the delegate of the former civilian government to retain his position, while representatives of the military junta have occupied seats at the Human Rights Council and even represented the ICJ in the case brought by the Gambia without the ICJ even discussing about the thing. Among specialized agencies, the World Health Organization and the ILO have deferred their decision pending guidance from the Assembly, and since 2021, no one has represented Myanmar in such organizations. Myanmar is actually also unrepresented at the IMF, and this is, to me at least, very interesting because in the IMF, when a controversial regime change occurs, the fund's decision depends on whether the majority of its member state, the majority is calculated on the basis of weight in voting power, so the most powerful states have more voice on such determination, recognize or deal with the new authority. So United States, 15.6% of voting power in the IMF has a huge influence. So even if a reform of the UN credential process, as necessary as it may be, remains unlikely, I consider that to ensure consistency, it's certainly preferable to rely on the decision made by the General Assembly, where all member states have equal voting power, instead of solutions like the one adopted by the IMF, where the most powerful states dominate the process. Last but not least, my last point on representation, it has to be underlined that credentials have been denied by the United Nations and specialized agencies as well. Even when there are no rival authorities, no Maduro Guaido regime, no junta civil government in Myanmar, but situations where a single government has seized power through non-democratic means. This goes back to the 1970s when the assembly rejected South Africa's credential due to its apartheid policies, and despite the fact that South Africa had incontrovertible effective control over the territory of the country. A similar situation is unfolding, however, today with regards to Afghanistan after the Taliban took power in 2021. In both instances, their lack of representation has come close to suspending the state. In the 50s, the UN Office of Legal Affairs noted that this use of credential to basically suspend a member state from the works and the activities of an organization, the organization would be contrary to the UN Charter, as it will bypass the rules on suspension, Article 5 of the UN Charter. I do not know, I had no time to verify if there is any legal opinion by specialized agencies on the matter, but the issue remains highly contentious, especially as some, as you might know, are advocating again for the expulsion, suspension, or at least the rejection of Israel's credential in light of the situation of Gaza. So this is what I'm going to write. Thank you.
Thank you very much. So we have a lot of time to discuss these two relations. And the first is, but you can ask both panelists together. The first is Professor Crema, and I wonder whether Mr. Nesi, Professor Nesi, want to ask, to say something. Yes. If you can, if you can.
Thank you very much, Mr. Chairman. I must say that first of all I have to apologize because I arrived a little late, and this did not allow me to listen to what Professor Sapienza. Hi, Saro, and thank you very much for being here. Although you are not here, but we would have liked very much to have you here. And I was able to listen to what Professor Fasoli was saying, and I think it was really a sort of model of presentation as regards our topic today. So now I'm wearing the hat of one of the scientific organizer. Thank you very much, Elena, for what you said. But now I have just to focus on what Luigi and Anna Maria Viterbo said, and so let me say a few words. First of all, I'd like to thank very much Luigi because he gave, first of all, because he said something that usually people at the ILC never say. The fact that the ILC is a rock of the UN system is something I will keep in my notes, and I will refer to my colleagues in Geneva when we are back to work on a daily basis. But I must say that I share this opinion, because I think that in a very complex and polarized world, the ILC remains a point of reference as regards discussions on the seminal topics of international law in in a very, I would say, constructive atmosphere. And this is something that, in my opinion, also should be a model for international affairs in general. Of course, there is a body of experts, so this means that we are there in our personal capacity, and this is something that changes a lot of politics, so to say. I do not say that there is no politics, but I surely say that, in my opinion, the ALC is a place where, and there are, of course, there is the evidence of these through the website of the United Nations, because what I discovered after many years is that there is a lot of transparency in the UN, and this is another important issue that must be addressed, in my opinion. While in the Security Council you don't know what's happening, but you know only the final result, although after the states say what they want to say, at the ALC everything is, I must say, 70% of our works are transparent, and they are broadcasted in the website. So this is it. You cannot say that there are hidden agendas in general. But I appreciate very much what Luigi said about the issues of fragmentation versus unity. It is true that we are in a world where there are phenomena such as the fragmentation of courts, the fragmentation of states, and fragmentation of doctrine. But at the same time, the great opportunity that the ALC has is that of trying, at least, to have to offer to the international community the real outcome of the debate on international law issues within the International Law Commission. And this is something that must be considered, in my opinion. So thank you very much, and I will really keep a lot of thoughts, and I look forward to reading your paper. If I have any other suggestion, I will try to tell them to you directly. And on the other side, as regards Anna Maria, I thank you very much for addressing a topic that usually is not very much taken care of by doctrine. I think that issues such as representation and membership and representation, both in the UN and in specialized agencies, is crucial, as it witnessed now recently also at the ICC, for instance. Now, you know, everybody is discussing about what is happening at the ICC. There are many rumors as regards the legitimate representation, the legitimate presence of Palestine, but nobody really knows what has been going on, and I think this is a very good topic for further discussion, among other things. So I do not want to make any specific question. I just want to congratulate both Luigi and Anna for different reasons, because, and I would like also to say that the aim of this meeting was exactly that of trying to single out reasons for contestation within the UN system, among different regional groups, and I think that Santiago Villalpando will say something very interesting on this when he writes his paper. And also because this is what we see today in our today's world, and as what said also yesterday by Christian Tamps in other landscapes. So I confine myself for the moment to just to this, and so I don't have any question. But since my name was made several times, I had to say something, and I thank you very much for this very important contribution.
Thank you. Thank you very much, Beppe, for your comment. Of course, all the audience waited for the comments by Professor Nesi, that is a member of the International Law Commission. Now, the floor is open. Sacerdote?
Yes, thank you. I have a
You have a microphone?
Yes, I have it. I have more a reflection on what Luigi said and a question for Anna Maria. The reflection, I mean, the traditional common mantra is that the ILC is not producing any more texts that become multilateral treaties, and this is a diminution, let's say, of its function and adds to the fragmentation of the system because the big multilateral conventions are not there anymore, and general international law is so produced indirectly, let's take the articles on responsibility by the reference to the work which has not been then taken up on the General Assembly of the Member States. You gave a different vision, say, maybe no, on the contrary, in a situation where fragmentation doesn't lead to multilateral conventions, the role of the ILC becomes even more crucial because it makes coalesce the development of international law. And you then, however, point out very much that this use is through the ICJ, which we heard yesterday from Christian. Now the docket is more important. There were years, there were few cases. So does it mean that custom is not produced anymore by practice and opinion and the work of the doctrine, but by a new de facto mechanism which is centered on the ILC work, even if more scholarly and not always completed with conclusions? That's my little bit provocative question. The question to Anna Maria is, you mean the specialized agencies? Nowadays, there are those which have UN in their acronym mostly and are the so-called family of the UN, but the World Bank and the IMF are a different kind, also because, of course, of the voting rights and membership. Let's see, for instance, you have also the WTO. Taiwan, under the name of Chinese Taipei, has become a member at the same time of the People's Republic of China. But there, of course, the rules provide that not only states but custom unions may be members. In fact, you say always WTO members, and one doesn't use technical expression for states members of the WTO. Even Macau and Hong Kong are in this category. So maybe this is not really a precedent, but it should be maybe taken into account the different mechanisms, different types of specialized organizations that are not really UN agencies.
Thank you. So we take about 2 or 3 questions before you answer. Other people want to intervene?
Yes, Serena Forlati.
Serena Forlati.
I would thank you both for very, very interesting presentations. I would just add something to the first prong of Giorgio's question to Luigi.
No, Serena, dicono che non si sente la...
It's dead. Adesso si sente?
Sì.
Sì, yes. Okay. I would just like to add a layer to Giorgio's question to Luigi about this interaction between the ICJ and the ILC, maybe other courts, investment courts even, and the ILC. and this change from that you highlighted from a function of preparing draft treaties to a function of a dialogue with courts more directly.
This symbiosis between the ILC and the ICJ specifically has been criticized a lot, and yeah, there's a problem with the
Okay.
Riprendiamo la tradizione del Hyde Park Corner.
Yeah. I will not repeat the first part, but the question is, you, I think, very aptly pointed out that it is not simply a dialogue between the ILC and judges. It's not that the ILC and international courts have taken up the legislative function that is so much dreaded as regards judicial development of international law. I think there is something in between, that is states' positions taken before these judicial bodies that also rely on the work of the ILC, and this acceptance by states of the ILC's work, also of judicial pronouncements, is a key element, at least in my view, of the actual impact, explaining the actual impact of judicial decisions in the consolidation and development of international law. My question is, states take a stance in different ways, not anymore by participating in big multilateral treaties or legislative efforts, but rather within the ILC. We should not lose track of that. States express their views to the ILC about whether its work is good or bad, and this influences the outcome of the ILC's work. And before courts, courts do not disregard the position that states take before them in taking their decisions, even if it's not only in contentious cases, but also in advisory proceedings. So my question is, do you see a difference between these two ways of expressing states' views and opinio juris and not really practice, but yeah, I wonder if you see a difference there between states' participation in big multilateral codification treaties, as it used to be, and these new forms of expressing their views. Thank you very much.
So thank you very much, Serena. And other questions?
I would have one, but if it's too much for them, perhaps.
No.
The more the better.
The more the better, no.
Royal Rumble.
Okay, so first of all, I would try to be as brief as possible. Giuseppe Nesi has already said you are very thankful when you engage with the keywords that we put in our subtitle, no? Contestation, resilience, and change. And I think that you're going to do that when you will finally write the paper, because this will ensure some kind of uniformity or common thread among all the various contributions which deal with very different topics. So thank you for that. And I will just address Luigi Crema's presentation, because, of course, I followed it very closely. I think that that presentation and the topic it is dealing is very important, and also, of course, also Anna's topic is very important, but I think that now I'm particularly concerned with your topic, which I think is very crucial within the overall economy of our symposium. And you never take this. Of course, I fully agree with you. It's impossible to deal with all the topics or themes and sub-themes that the ILC has dealt with within its life. So I really favor your approach of focusing on, say, the broader dynamics within the ILC, what happens there, what are the conclusions which we can draw from the relevant practice. So, for example, I said that you never concentrate on this, never-end, say, classical topic of the pendulum between codification and progressive development of international law. And I think perhaps that could be, let's say, a suggestion for when you write your paper, whether that tells something about contestation, resilience, or change. I mean, concentrating on this classic alternative between codification and progressive development. On themes, specific themes, I have one suggestion about a topic dealt with by the ILC, which I know pretty well. Of course, I don't know much about many topics. I know something about some topics. And one striking example, I think that unprecedented dynamics within the ILC is what happened within the works on the immunity of state officials from criminal jurisdiction. Because I think that there something unprecedented happened. You find some kind of dissenting opinions by certain members of the ILC, led by Michael Wood, which wrote their dissent in very clear terms, and the commission there was very, very visibly split. And you know, that division happens every day, but in that particular case was written, so it was on record. So this is just a suggestion, it's not a question.
Thank you. So I keep another question before I give it the floor.
I have a question for Luigi.
Yeah. One more. No, from the audience, so it's from between the panelists. This is a question by Viterbo.
Yes, I feel I first answer Professor Sacerdotti's question, and then I put you a question.
Just put the question.
I put the question. Okay. So my question is about the ILC guidelines. This instrument that the ILC is using more often in the last years, which to me is a little bit like a pushing practice in a certain direction when there is no sufficient practice. But I don't know if you agree with this kind of reconstruction, and what do you think about that specific tool that the ILC is using?
Okay, this is the first round of questions. Please. So you can. Yeah, to all, yes, to all.
Okay.
Yeah.
Professor Sacerdoti, I didn't mention it at the beginning, what it was the scope of my research, but I'm going to deal only with those organizations that have signed a relationship agreement under Article 57 and 63 of the UN Charter with the UN, which the WTO has not. But thinking about custom unions.
But it has an agreement with the WTO, maybe not under those articles.
No, it's a separate thing, but it is not in the family of UN specialized agencies. There is the UN World Tourism Organization, which is a UN WTO, but it's another different organization, different topic. On membership, you mentioned membership participation right to custom unions. For instance, the IMF has nothing like that for what concerns currency unions, which is something that is missing. But I will check whether the other specialized agencies have anything about regional organizations, something like that, but I do not think so.
Okay, so.
No, but sorry, I wasn't speaking of which organization.
No, I know.
One as a separate custom territory. That's the definition. So independent for custom purpose, even if politically like Hong Kong, is part of the People's Republic.
Okay.
So I go in reverse order. So I also ask a clarification. So you asking me, what do I think about the use of guidelines as a way to codify and develop? I will answer also to Riccardo with this and the idea of progressive and codifying law. So I take together the two questions. First of all, I was with my mentor, Treves, when those works were concluded. on the immunity, and of course I forgot. So you brought me back a great memory of my PhD. Okay, so thank you. First of all, when you started talking, I was thinking more that you were leaning towards the environment in armed conflicts that has very interesting issues, not just that, but also codification of like 50 years of work and also knowing your keen expertise on the topic. So I was kind of shocked for two reasons. So that's a great suggestion. Thank you. I will include it. Codification and progressive development. So here again, I step back and I look at history, and there is a huge genetic moment in the genealogy of international law that we inherited. Article 19 of the 1996 AGO project on state responsibility is a dark or beautiful, whatever, milestone that set the next quarter century. The most recent attempt to develop international law was brought out by the ILC and coupled the notion of crime to a distinction in the offenses in the wrongful acts, and was rejected. Was rejected because it was too progressive, whatever. But Crawford became famous at that point, just taking scissors and removing all the problems that state practice was giving, and he went bare to the bone. So Latin disappeared. Jus cogens was just for the VCLT, and we just talk about peremptory norms. Article 19 away. We just have a flat torts system with strict liability imported into international law.
Settlement of disputes.
Settlement of dispute, absolutely. So that's the precedent. Progressive development is something that, in a certain way, was stopped by these two-step, 1996 AGO versus 2001 Crawford, and gave a lesson that when there are doubts about the progressive development, the place where the development happens is with judges outside. So we try our work, we don't dare to force, we put an idea and we'll see how it goes. On this, I'm a bit, again, son of Treves in the fact that pragmatically you step back, for example, as with reservation and objections, and then you see where the judicial practice goes and see what to do. So just to conclude on this, sorry, I'm too long. In a certain way, maybe I'm replying also to use 2 pages on Professor Sacerdoti. So when you have this homogeneous practice, the ISC can do 2 things: to be overly descriptive, as for Pelé and for other works on reservation, or to make a choice. And you draw a guideline. You draw a conclusion that is in part different from the practice. And of course, you have to be able to water down the process away from the commentary. Okay, so you leave in the reporting the discussion, and the commentary brings to light only the relevant practice for the final guideline. I think that on this, a successful example, it's not the most important thing, so it was not heavily contested, but successful example comes from unilateral acts of states approved in 2006 and often used by the parties and therefore by arbitrators to organize an interpretive reasoning that is not strictly linked to good faith as for Article 31 and 32 of the Vienna Convention, but it should be linked to good faith and unilateral statements. So good faith applied to unilateral statements bring to different results. And therefore, the ISC developed the principles to interpret and apply unilateral statements through a set of guidelines. What's their normative value? When someone can say, what's the normative value of the Vienna Convention on the Law of Treaties as far as interpretation is concerned? No. So what if you disobey, from that? So treaties and their norms sometimes are very useful because that's again me talking only. I'm not referring to the ISC, but in providing order to the confrontation. So I look at the judicial moment again, and these guidelines and the Vienna Convention on Article 31 and 32, okay, so on this specific part and not the rest, are useful not just because they bind, but because they provide an orderly approach to litigation, setting a set of questions and answers that they have to go through in front of a judge. So guidelines, yes, can be useful, and again, have been used in many occasions because they give order to the important priorities that parties have to discuss before a judge. And then I conclude now, I'm coming to the judicial part and Serena. 3 points. So first of all, I think it was Agemacher in his seminal work on the 2 elements of custom that concluded saying that judges have the master key of this operation of weighting practice and opinion. Actually, states have to craft it. No, so he concludes his seminal work on the 2 elements written in the 80s, moving away from North Sea and Lotus and just saying whether it's in the attorneys, it's in the, you have to look at what happens at the bar to see how custom is developed. Linking again state practice to the genetic moment of custom. So therefore, I'd say not just division, treaty versus practice, but treaty versus state practice versus state practice presented before a court. This was discussed a lot in the works on customary law, and of course was a clear problem before. Not always what states say in front of a court can be considered an expression of the political engagement of a state with that rule in the international arena. So a sort of buffer that certain scholars attribute to states in the judicial moment, because the practice in front of a court is not always reflecting what the states actually put in place. So those are, it's just to make it even more complicated, 3 moments. Now the state practice towards the ILC, the treaty, the practice of developing a treaty, and the judicial practice, the state practice before the judicial body. So I see, in I would stay in the middle. No? The judicial practice is a bit biased. It is difficult to attribute to it the decisive role. I see more in the couple of state practice in general, plus the judicial practice that distillates it. And distillates what the parties brought before them, saying, well, that's actually true and that's not true. Okay, that gives order to these competing claims. Again, not in making a rule, but as for the precedent, in using it as a way to express the underlying state practice. So that the judicial moment peaks these competing claims, and without sealing it in a rule, reveals the underlying customary rule that these claims are bringing out, as they do for often judges with the precedent. We're not using the precedent, we are just referring to Mavromatis because we don't want to engage on the definition of dispute, but not because we think that Mavromatis is a precedent. That's impossible in international law. But we like the reasoning there and the customary rules underneath. So in the same way, I see this dialogue between the work of the ILC, state practice, and the use that the judicial bodies do of it. Not clear.
Okay.
No, because you look obliquous. So.
Excuse me. If we want to pose other questions, you can do it. Serena, you want to say something again?
I have just a lingering doubt as to whether statements of states before international courts are practice. I rather see them as opinio juris, but this is...
No, I agree. In fact, I introduced the distinction to play a bit with it. No, I agree.
Okay. So we have enough time. If there are other questions, please.
Maybe they come from
Okay.
Mark.
Mark, please.
Yeah, thank you very much. I have a question for Luigi, and I wanted to link to Professor Forlati's point because she said what I wanted to say, but I wanted to build on that. But I believe this ascending phase, using by analogy the words of European Union law, the ascending phase, the participation of states in the ascending phase is very important because one could take the view that assuming states can be taken as rational actors, which is quite something. But let us assume they are rational actors. If they cared, I mean, they would take part in the procedure. They would submit regularly observations, and Professor Nesi can explain. They don't. They do that in a patchy manner. They do that from time to time. There are cases in which, based on my, of course, not so developed knowledge of the system, but based on what I observed, there are cases in which you see voluntary intervention of states. For instance, persistent objector is a key issue, where you see they intervene in the ascending phase, especially affected states. That is a key point, and you see some of them intervene. But I can see an overall assessment of what they do. I mean, that perhaps does not substantiate your finding that the ILC is a rock in the UN system. Because I wanted to question your point. Is it a rock in the UN system? If it is a rock in the UN system, they would take part in the ascending phase, and indeed they don't so much. So that just for the sake of the argument to question your point.
Okay. Other questions, please?
Christian Tams.
You?
Christian Tams.
Tam, please. You can come here.
Thank you. There is a bit of Hyde Park to this, walking up. So, Luigi, I have a question to you, a comment and a question, and perhaps it touches upon the other presentation as well. But so I think I'm struck by what emerged in the discussion, the focus on the link between the ILC and adjudication courts, tribunals as the entities that eventually approve or grant imprimatur to what the ILC says. And I think that prompts me to offer one comment and perhaps 1.5 questions. So the comment is, I think, one thing that I find striking in that, but entirely subscribe to, is that perhaps this concern about the ILC no longer producing draft treaties is completely overstated. If the essential function is to produce something that others will ratify or approve, then maybe it's better for the ILC to produce something that is not meant to be as a treaty, or at least it's not principally inferior. And I'm wondering whether you would agree with that. It seemed to me to follow from at least how the discussion has gone. But then my question is really whether we should focus so much on that aspect of the ILC. It seems to be, you labeled it a rock, and I think I too like that. I mean, it's on rock that churches are built, and rocks are steady and steadfast. But is it not more a think tank, a producer of ideas? And wouldn't we need imagery that captures not stability and steadfastness, but this dynamism? The dynamism coupled with the lack of, well, not lack of authority, because of course these are good ideas and they are worthy to be looked at, perhaps unlike what we write as individual scholars, so they deserve probably more attention. But I'm not sure about the rock metaphor. I want to like it, but I think the discussion shows rather something different in the way the ILC functions in the international legal system. My 1.5 question is, if we really see the ILC as a producer of ideas that need validation, and and if we further follow you by emphasizing validation through courts, then I think I'm not going to discourage that. That's obviously a relevant part of how international law is crystallized. And it's probably better than amorphous procedures of state practice, opinio juris, the guesswork of is it custom or not. So I'm not against that, but isn't that a very reductionist perspective that leaves out, let's say, all of the work that was covered in the specialized agencies presentation? All of the work that touches upon areas that are not prone to judicialization, and yet the ILC still manages to produce something. So if the ILC works on the diplomatic bag, it's pretty useful, but it's not likely to be endorsed by the ICJ. Of the ILC's work on non-navigational uses of watercourses, perhaps occasionally endorsed by courts, but ILC's work on state succession and nationality, not validated by courts and yet useful. So how do we account for the ILC's influence in the fields that are not routinely judicialized? And if we place so much emphasis on validation of a particular type through courts and tribunals, aren't we reducing the ILC's role, whether it's a rock or a think tank? Thank you.
Thank you. We have time for other questions, please.
Thank you.
So, can you say your
Alessandra Arnoni. My question is for Anna Maria. I was wondering, you were talking about representation of governments, and I was thinking, how does this practice of not recognizing effective governments, for whatever reason, does it comply with the principle of non-intervention? Is it against it? And if it is against the principle of non-intervention, what justifications can be put forward for such a practice? Is it a sort of countermeasure that we adopt, or that some states adopt, because they consider that this government has come into existence through a violation of use Kogan's norms or whatever, or is there another justification for this? Thank you.
Thank you. Anna, please.
Giulio Bartolini.
Giulio Bartolini. Giulio Bartolini? You can come here, it's better.
So thanks, Giulio Bartolini. I have one question for, just a remark for Luigi, whether your interesting analysis could be partly also be reshaped also by the decision made just last week by the CIS committee, which finally gave the green light for 2 negotiation process based on the ILC text. Basically, the decision was made to have a resolution next month by the UN General Assembly for going to negotiation both for the treaty on disaster as well as the treaty on crimes against humanity. So in this regard, maybe the validation still comes from states, because ILC made projects which were fit for becoming treaties. And of course, we know more and more the ILC, as you said, is not looking for topics going to be a potential binding instrument at the end, but mainly working on issues which are even too much theoretical again, or something which, on the contrary, could be helpful for the adjudication aspects. And the example of the new topic on compensation, for sure, could be one of them. So also in this regard, maybe also one of the lack of capacity for the LC to adopt new treaties was also on the increasing trend toward topics which were not fit for being a treaty. So maybe also in this way could be an element to be reflected also. Just the idea of to have 2 new treaties on the LC draft articles, I think, is quite something relevant for your paper as well.
Okay, so if there are other questions, I guess first I want to give the floor to the 2 speakers, because there were a lot of questions. Please, Professor Michael or Professor Craig.
Thank you. So, Alessandra, what I'm looking is the recognition practice inside the of credential inside the United Nations. So the credential process has seen an evolution, and in practice there are no established rules when there are credential challenges. The only attempt made by the General Assembly to solve this gap was in 1950, again with the issue of China and the People's Republic of China established in Beijing. So, but it didn't really solve anything because I'm quoting, the resolution text says the questions should be considered in the light of the purposes and principles of the Charter and the circumstances of the case. So basically, you can do whatever you want, but the history of the credential process inside the UN shows that until the 90s, basically, they decided on the basis of effective control without looking into other issues like gross violation of human rights were not taken into account. Then after the 90s, such additional factors were considered, starting from human rights violation and other violation of use of force, these sort of non-democratic ways to obtain power. So this marked a departure from previous practice, and this is where we are left, basically, with this huge gap in the system, where basically the Credential Committee, before addressing its recommendation to the UN General Assembly, can do whatever they want. It's a small group of states. China, Russia, and the United States are always there. So this explains all the criticism because it has been used in a very politicized way. So,
Professor.
Okay, thank you for the other great questions. Now, I organize conferences too, and I ask to talk 20 minutes, and then the person talks 45 minutes. I see why. No, because then there's no time for the questions. Okay, on my own skin, I respected the 20 minutes. But no, this is great. Great format for the future. Just stick to the 20 minutes so you can develop more points in the debate, because the last point, I start from Giulio's point. It is part of my reflection that, of course, I did not address, in part because I'm forgetful, in part because of the limited time. So the question of the topic and what is the best instrument to address the topic. I agree. No, so the fact that the General Assembly, so the committee, the General Assembly, and then states, we'll see if things go in progress, no? We'll move, maybe in part, to address the criticism of states not willing anymore to take the risk of a diplomatic conference. We'll go to the final end. And the final end is not just the adoption of a treaty, but the adoption of a treaty and a widespread ratification. So this is a risk, because we can end up with a treaty with very little ratification that can be used in litigation as an evidence that those rules do not reflect commonly accepted standard on the topic. So that's okay for many topics. For example, for criminal law, the inclusion of the work of the ALC in a final written text is absolutely fundamental. And that's basically how we built criminal law in the last phase, in the 90s, in the work of the statute. The two institutions, so the debates in Rome and the ISC worked together on certain issues. And they ended up in the work we use now in our classroom, and for many people also as practitioners. But so criminal law has to be hard and clear. No? So absolutely the topic calls for it. The disaster one, we'll see. But anyway, I made my point. That the risk of a treaty is still there. Only 32 states ratified out of 194. That means that they don't reflect anything. Well, if we have just the text up for comment, it's the practice. It just reflects in the practice, and you can oppose it anywhere. stepping to, so this led to the question, and how about the work that doesn't happen in front of any judicial body? I agree. So states, first of all, are the engine of international law. They are the subjects, the users, and in many areas, they do it either alone or with international organizations, or maybe international organizations alone do that. So what's the status of this theoretical account that I gave facing these rules? It's partial, I agree. So it doesn't encapsulate any useful finding for that, aside from the dialogue, the moment of dialogue between states with each other, and we don't know what happens there if the work of the IRC is used by states, just because it's not public. But even more with the work with international organizations. That I would dare to say that the IRC is useful, even if without the judicial moment. I speak about the judicial moments just because it's very public, no? But there are other possible ways. When I had more time than now, I remember I accessed a database with Italian practice on a given topic, and I was surprised to see that they were quoting the Vienna Convention on the Law of Treaties. Positively surprised. No, just a very quick reference to that article. Nobody will ever quote that as an important judicial practice, just because it's not accessible through a normal database. I had to browse, the static pages of practice that were published by, I don't remember where. Maybe it was was part of the Trento thing. Yes. Maybe it was part of the Trento database. No, I was studying a topic, I don't remember, but I think it was that. No, was practice, was just documents. Yeah, it was Trento database. So I do agree that it's a different word, but in part we don't capture the dynamics of this word just because of lack of publicity. But I share the concern of just building one theoretical framework for the work of the contemporary turn of the IRC. The metaphor of the rock was problematic for Marco too, and for Christian. So while you were talking, came to me that the rock, the choruses from the rock is a beautiful poem by Clive Staples Lewis, and it talks about the disruption of contemporary world and the rock that remains and the disruption of it. So probably the image of the rock came to me as related to the fragmentation and the contestation. That one is in the theme, the contestation, and the other is part of the last work of us as scholars in the last years, to deal with the unity running away towards peripheries, towards new topics, and but as James Crawford said, in commenting the IRC to the center holds, quoting another Brit poet, William Yeats. So I put together two poets. I go into different regimes. I jump out of the legal to build the concept we have to take from other languages, and I go into poems. Is the center holding of international law? Yes. No. Is the center holding in the way we're used to? No. Why I use the image of the IRC, living psychology aside, I use the term rock, probably because of these waves that many people, it's more cool to talk about problems, and I'm one of them. Sometimes we have to remember that there are things that sail through problems without feeling much, like an oil tanker in a storm. Yeah, there are big waves, but the oil tanker keeps going with a different agenda. Okay, I associate the ISC to this oil tanker. Is that fast enough, like a think tank would be? No, it's slow. So, because it's not a think tank. It changed a bit of a skin, so from a dusty maker of diplomatic staff, it became more open to slippery topics, without leaving them just for scholars, but took very difficult topics, but still sailing it with a lot of oil in the belly, a lot of state interest anyway looking. And states don't intervene much. I agree with Marco. I'm always shocked by the lack of response by very well-staffed diplomatic missions. You would expect that at least one intern would be interested in that topic, but there is some strategy here too. But I leave aside the reflection on the strategy of not participating, and I just come to your question. If it is a rock, why they don't take part to the process? Well, maybe because the legitimacy doesn't come from their participation. The legitimacy of the process, given the quality of the work, it's not just a think tank, but it's something different, can resist the lack of initial legitimation. The process can start quasi-independently from feedbacks from states. The first feedback comes from state members of the General Assembly, so the kickoff is huge. Okay, the work starts with a big blessing. And then they detach a bit because they trust the work. Then they go back. Then they go back if they need, or otherwise they just wait because they don't want to deal with it. They don't want to deal with the possible consequences. So I'm not, sorry, I'm a bit obscure here, but not on purpose. So what I mean is that sometimes a clear solution to certain problems that the IRC deals with are not really fitting into state interest. It's very clear that states have a certain interest, but they don't want to pursue it for certain other interests, like reputation and other stuff. So using an Italian expression,
you close, please.
The IRC takes the chestnuts out of the fire for states that are happy not to deal with the process and just look at what happens to the outcome. Okay.
So thank you very much. During the lunch, you can have the possibility to speak each other. I guess we are starving, deep discussion.
With the chestnuts.
Do not fill your stomach. And I want to terminate the meeting some minutes before. So before terminating, I will ask Riccardo Pavone if, yeah, and after Serena Forlati will close the meeting. But I ask first Riccardo Pavone to say something about this meeting.
Thank you, Professor Ronzitti. Just a couple of words, given the time, and we are very grateful to all the participants here. I think it was a very engaging meeting. I learned a lot. I think it was very brainstorming session on many topics. So I think that there is this really promising for our next volume, and we are really looking forward to receiving your papers and to reading your final conclusions.
Thank you. Now I will call Serena Forlati to close our meeting, that we can express a lot of thanks to Serena for the beautiful organization of this meeting. Please, Serena, you close the meeting. You are our host.
Thank you also for this honor, but just let me say that it has been a real pleasure to host you all, to engage with the speakers. Luigi, yes, it was a trial, I know it, but I think the discussions made really a lot of the fun and privilege of being involved in this meeting. So thank you also for enduring the drilling from the audience. The topic is very hot. The inclination to lean towards pessimism needs to be fought, I think, and I personally received a lot of input that helps me fighting pessimism in these troubled times. And I am very glad that we could have the discussions here in Ferrara. Thank you so much to the whole group of the Italian Yearbook and for all those present here for accepting to engage in this. Thank you so much.
Thank you, Serena.
Let me just say thank you to Cristina Gavric and Marilu Porchi. I forgot yesterday.
Sorry, I haven't forgotten. Very good. So the meeting is closed. The lunch is waiting for you.